Hello and welcome to the Minimum Competence episode for Friday, April 4th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover GOP-led states targeting law firm DEI practices, a proposed Millionaire tax hike, and legal scholars backing Perkins Coie against a Trump order. Let's remember, when goods do not cross borders, soldiers will, and read today's legal news. On this day in legal history, April 4th, 1968, civil rights leader Dr. Martin Luther King Jr. was assassinated while standing on the balcony of the Lorraine Motel in Memphis, Tennessee. King had traveled to Memphis to support striking sanitation workers, emphasizing his ongoing commitment to economic justice alongside racial equality. His death sent shockwaves through the United States, triggering riots in more than 100 cities and accelerating the passage of key civil rights legislation. King was a central figure in the American civil rights movement, having led campaigns against segregation, voter suppression, and economic inequality. His advocacy relied heavily on nonviolent protest and legal strategies that tested the limits of constitutional protections and federal civil rights enforcement. The assassination drew intense public scrutiny to the federal government's role in protecting civil rights activists. James Earl Ray, an escaped convict, was arrested and charged with King's murder. He pleaded guilty in 1969, avoiding a trial, but later recanted and sought to withdraw the plea. Controversy surrounding the investigation and conviction has persisted for decades, with some, including members of King's own family, questioning whether Ray acted alone or was part of a larger conspiracy. King's assassination directly influenced the U.S. Congress to pass the Civil Rights Act of 1968, also known as the Fair Housing Act, which prohibited housing discrimination based on race, religion, or national origin. The legislation had faced significant resistance before King's death, but was passed just days afterward. His assassination also galvanized greater federal attention to civil rights enforcement under the Equal Protection Clause of the 14th Amendment. A group of 12 Republican-led states, including Texas, Florida, and Missouri, has asked 20 major U.S. law firms to provide documentation on their diversity, equity, and inclusion, or DEI, initiatives. The request, led by Texas Attorney General Ken Paxton, seeks to determine whether the firm's practices comply with federal and state anti-discrimination laws. In a letter sent Thursday, the states referenced recent concerns raised by the U.S. Equal Employment Opportunity Commission, or EEOC, which had previously asked the same firms for similar information. Paxton cited potential violations of Title VII of the Civil Rights Act, alleging that some law firms may use hiring policies that prioritize race, sex, or other protected characteristics. He also pointed to possible state-level violations, including those related to deceptive trade practices. The letter specifically called out programs such as diversity fellowships and hiring goals aimed at increasing representation from historically marginalized groups. The states argue they have the authority to investigate and enforce laws that prohibit employment discrimination, including policies that may inadvertently or intentionally favor individuals based on race or other traits. Firms named include top legal players like Kirkland & Ellis, Ropes & Gray, and Skadden Arps. Republicans are considering a significant shift in tax policy by potentially introducing a new top tax bracket for individuals earning $1 million or more annually. The proposed rate, currently under discussion, would range from 39% to 40%, marking a departure from the party's long-standing resistance to tax increases for the wealthy. This idea is part of a broader effort to offset the cost of multi-trillion-dollar tax packages being developed by Trump administration allies and Republican lawmakers. Also on the table is a return to the 39.6% top income tax rate previously enacted during the Obama administration, replacing the current 37% rate for high earners. The GOP aims to pass the new tax legislation within months, renewing provisions from the 2017 Tax Cuts and Jobs Act while incorporating new deductions and reforms to appeal to middle and working class voters. Treasury Secretary Scott Bessent has emphasized the urgency of making Trump's earlier tax cuts permanent and stabilizing markets following recent tariff announcements. The evolving plan reflects a broader ideological shift within the Republican Party toward more populist economic messaging, if not actual policy. To help pay for the new tax measures, the proposal also includes eliminating the carried interest loophole used by hedge fund and private equity managers and expanding deductions, such as those for car loan interest and tipped wages. Trump's campaign promises, including removing taxes on overtime pay and Social Security benefits, are being considered for inclusion as well. Over 300 law professors from top institutions, along with legal advocacy groups across the political spectrum, have filed court briefs supporting Perkins Coie in its lawsuit against an executive order issued by Trump. The order, signed on March 6, penalizes the law firm for its work with Hillary Clinton and its internal diversity policies by restricting its access to federal buildings, officials, and contracts. Professors from Yale, Harvard, and Stanford argued the order is unconstitutional and undermines the independence of the legal profession. Their brief warned that targeting a firm for political reasons threatens any lawyer or firm that chooses to oppose the president in court, calling the order a dangerous precedent. Advocacy groups such as the ACLU and the Cato Institute echoed that concern. labeling Trump's action an attack on the legal system and a threat to Americans' right to legal representation. The White House responded by defending the order as a lawful measure to align federal partnerships with the administration's policies, criticizing the lawsuit as an attempt to preserve, quote, government perks. Meanwhile, the Justice Department has requested that a Washington federal judge dismiss the lawsuit. Other firms named in similar orders, Jenner Block and Wilmer Hale, have also filed suits, while some, like Skadden Arps and Paul Weiss, have made agreements with the White House to avoid sanctions. Cowards. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter form. We'll see you back here on Monday, and until then, note, we like to close out the week of shows with a featured musical piece. That will make these Friday episodes seem especially long. We hope you'll stick it out and enjoy the featured piece, but if music, and specifically classical music, isn't your bag, we get it. Our mouth sounds unrelated to the week's closing music ends here. This week's closing music comes from one of the most innovative and influential composers of the 20th century, Igor Stravinsky. Known for his revolutionary works like The Rite of Spring and The Firebird, Stravinsky continually reinvented his style throughout his long career. Born in 1882 near St. Petersburg, Russia, and passing away on April 6, 1971 in New York City, Stravinsky's life spans continents, world wars, and artistic upheavals. While he is best remembered for his large-scale ballets and orchestral works, he also composed for smaller forms, including a fascinating piece titled simply Tango. Composed in 1940, Tango marks Stravinsky's first original composition written entirely in the United States after his move from Europe. At the time, he was living in Hollywood and adapting to a new cultural and musical environment. The piece is short, dark, and rhythmically sharp, more brooding than danceable, and carries the flavor of the tango tradition filtered through Stravinsky's idiosyncratic angular style. It was originally written for piano, though Stravinsky later orchestrated it. Tango reflects Stravinsky's interest in blending traditional forms with modernist dissonance and unpredictability. It's a brief but compelling listen that offers a very different side of a composer often associated with thunderous orchestras and ballet scandals. Its rhythmic complexity and stark character echo the uncertainties of the time it was written, just as World War II was escalating. The piece serves as a reminder that even in exile, Stravinsky continued to experiment, innovate, and absorb new influences. As we remember his death on April 6th, tango is a fitting closing theme. Wry, lean, and unmistakably Stravinsky. Without further ado, Igor Stravinsky's Tango. Enjoy.